As my colleagues submitted, I kept on asking myself, where could have been the origin of this word accountability in Article 10 and Article 81 of the Constitution? I happen to be a Christian by birth and by orientation, and of the four Gospels, the one I find most accountable is the one by Luke. This is what Dr. Luke, he was a medical doctor, wrote to the Roman consul, Luke chapter 1 to 4. I always prefer the King James Version, but I don't have it. In as much as many have taken hand to set in order a narrative of those things which have been fulfilled among us, just as those from the beginning were eyewitnesses and ministers of the word, delivered them to us. You see, the preceding Gospel writers were ministers, they were Pharisees. This one was a medical doctor. It seems good to me also, having had perfect understanding of all things from the very first, to write to you most orderly account, most excellent Theophilus. Orderly account.
Amen.
An orderly account is the genesis of the requirement for accountability and transparency. Imagine today, 2,000 years after, the account of Jesus is authenticated by 4 men. Not by what Jesus wrote, by 4 men. A man stood here and told us these were the results of the by-election for Malava Constituency. A man, one man. The same man admitted in cross-examination that contrary to the requirements of the election regulations, he did not have a list of accredited agents. Judge, Part 7 of the election regulations domiciles the constitutional dictate of accountability. That is Part 7. We begin from the Regulation 59 all the way to Regulation 79. I will underscore. Regulation 57 requires that the list of agents be submitted 14 days to the date of the election. 14 days. And permit me to enumerate the necessity for agents. Under Regulation 62 on admission to polling station, the fact of admission must be authenticated by an agent. So that's the first step. Admission to the polling station. Under Regulation 67, the sealing of ballot boxes before the commencement of the poll must be authenticated by parties or their agents. Regulation 68, Subregulation 5, the process of voting must start with the authentication of agents. So that is process number 10. And under Regulation 79, Judge, the counting of votes and the declaration at the polling station must be authenticated by the agents. 4 cardinal processes. Yeah, you posed a question to the returning officer. So what is to happen when the list of agents is not submitted 14 days before the election? The returning officer did not give any answer. But to explain away, he said all the candidates who are apprehensive that their agents will be infiltrated. That is not an answer. The answer is found in what the Court of Appeal stated in the case of James Omingo Magara versus Manson Nyango Kumwere. And the Court of Appeal pronounced itself as follows, if I may just state the summary. An election code is perfectly entitled to, indeed, I will go so far as to say, such a court is bound to examine whether the election and its attendant process were transparent, free, and fair. So where there is no compliance with those 4 steps, then the conclusion the court should make is that the election was not transparent. And Judge, as you retire to write your judgment, could you look at the judgment of Riaga Omolo? He defined what transparency is: to perceive with a looking glass, to see at the bottom for clarity. I, standing here as counsel for the petitioners, can state affirmatively that the testimony of one individual, the returning officer, does not pass the transparency test. Still on that point, another answer is found in the decision of William Kabor Vitao versus John Cool. This is what Justice Luka Kimaru, then as a High Court judge, stated, the participation of candidates or their agents is not incidental or cosmetic to the process, but is an important component of the electoral process. An important component of the electoral process. And he concludes, that is the reason why the election regulations provide that at each stage of the electoral process, the candidates or their agents participate in the process. Guys, English can never be written in any other clear terms. Now, let us just interrogate in two instances why the failure insofar as the four-tier process is concerned reshapes this election. During the testimony of the chief agent of the third interested party, that is Jared Karani Siniha, his testimony was twofold. He testified to the fact of the attack on the designated talent center of the third interested party, the attack, the destruction of talent equipment, and the destruction of talent materials. With what results? Disorienting the tallying plans by the party. The second aspect of his testimony was, throughout the polling day on the 27th of November 2005, he would not take account of his agents who had been discussed. And some who had been denied entry in the polling stations. What was the result? He could not have the chief agent authenticate the results presented by the second respondent to him for his signature. Jared Karani Siniha withheld his signature on Form 35B. Jared Karani Sidiha withheld his signature on Form 35B. Judge, if this lamentation was to originate on the third interested party alone, then it could have suffered some credibility concern. But that's not the case. When David Dako stood here, he was asked questions. Primordial amongst those questions was whether he had a list of agents. He said no. He didn't have a list of agents. He was asked whether he could independently authenticate the results he garnered. He said no. Dako was asked whether he could independently authenticate the results he garnered. He said no. Dako is in the position that Mike Ibaki was on that night. When he said, mimi sijui aliyeshinda, nimeambiwa tu nimeshinda. And we know what followed there. Accountability is the hallmark of a free and fair election. And accountability, Judge, necessitates that the process and outcome be capable of an audit conducted independently by the candidates or their agents. That was not the case here. And then they will tell you, the advocates for the IBC and the returning officer and the advocates for David Dako, that how did it affect the outcome, the margin of win? No, it did. This is the best example. Take 10 oranges to make orange juice. You remove one orange, you add an avocado. That cannot be orange juice. It adulterates the outcome. It doesn't matter the pinch of adulteration. It adulterates the outcome. It is not the quantitative test, it is the qualitative test. Here's the next example. We were treated to a spectacle here when one gentleman, Moses Mulambula Masanza from Kamuchiso, testified. Judge, in the cross-examination of this witness, the advocates for the IBC, the returning officer, and David Dako, pinned him to to Kamuchisu polling station as the agents of the third interested party. That is what they sought to extract from him. Yet, Judge, the agent, Benson Juma, had earlier on testified of how his entire family had been attacked the previous night. Occasioning his inability to vote at Kamuchisu and to be an eyewitness to the election process and outcome at Kamuchisu. Judge, when the ballot box was brought here and opened for the examination of the Form 35A and the polling station diary, a damning disclosure came to fore. Number one, it transpired from the Form 35A that it had been signed according to the IBC by Moses Malava Constituency. Yet, in actual fact, Moses Masanza himself had sworn an affidavit that he never appeared at the polling station to vote. If the fact of his presence at that polling station as an agent for the third interested party was so crucial, then why was it not presented by way of an affidavit in response to the testimony of Moses? Why? That is the question that the court must ponder over. Why? Another question that the court must ponder over is this. There was no presentation by the IBC and the returning officer of an authorization letter by DAP and or the third interested party designating Moses Masanza as an agent. Why? Judge, in the anatomy of murder, it says, even the smartest of all will make one mistake out of 15 concealments. This is the 15th concealment of the smart ITC. The polling station diary indicates that Moses Masanza entered the polling station at 15:48 hours. 15:48 hours. Yet, he is indicated to have signed on the polling station diary at 6 in the morning when the ballot box was being sealed. Judge, you can fool some people sometimes, but you cannot fool all the people all the times. Lastly, on that issue, The polling station diary does not indicate when Musa Masanza exited the polling station. Judge, what do we make out of this? Falsification of the declaration of results, to misrepresent that they were accurate and capable of independent audit. The last witness on this issue was Tom Combo, the agent for the third interested party at Kalenda polling station. He testified, and before the testimony, he put an affidavit of his removal from the polling station by David Yakwa and policemen. There was no replying affidavit by the presiding officer from Kalenda polling station to deny or give us an account as to what happened. Similarly, Judge, there was no replying affidavit by David Dakwa to deny this fact or give his account on what happened. What are we supposed to make of these undisputed facts? Judge, an election process that cannot be subjected to an independent audit for authentication is a sham. We submit that this issue has been proved. There was no accreditation of party agents. The agents of the third interested party were specifically targeted because of that want of accreditation. Can the returning officer, like Luke before him, give a true account to you, Judge, with the equivalent of the Roman proconsul? No, he can't. He cannot. Like Theophilus before you, you must reject this account. Judge, I'll have time to put a rejoinder after listening to what my colleagues have said, but let me just say 3 lines of conclusion. The only arm of government that did not have an interest in this by-election is the judiciary. The executive had an interest. It deployed the principal sector, Ministry of Higher Education, to secure the outcome. It deployed the cabinet secretary in charge of foreign affairs as the principal cabinet secretary to come here. Parliament had an interest in this election. The two speakers of the houses were here. Amason Jefferson Kingi was here. Moses Wetangula was here. The one who we have presented an authority have the propensity of doing these things. The judiciary is the bastion. The judiciary is the bastion of justice, law and order. We beseech you, stand out. That takes a lot of courage. When your brother Justice Gikonyo invalidated the election of Moses Wetangula here, he had to be recorded by Nico. I was here, you know. When Daniel Musinga invalidated the election of Omengo Magara, he had to be recorded. As we know in the current constitutional dispensation, your judge is the most protected person to give a fair and just determination. We ask you to allow this petition with an order for costs and to recommend to the Director of Public Prosecutions, just as the Kenya National Commission on Human Rights have said, to investigate and prosecute the perpetrators of state officers' participation in this by-election and of bribery. That is all we ask of this court. We are most obliged.